So in Alabama, what happens after a drug trafficking arrest? The first issue that comes up is getting your loved one out of jail, and that's not always so easy in a drug trafficking case. The reason it's not easy is because Alabama allows the bail, the amount of money required to be paid for a person to get out of jail, for the bail to be set very high on drug trafficking cases. The minimum is $5,000, but the maximum is $1.5 million. And let's face it, most people don't have $1.5 million laying around that they can give to the court system to say, oh, hey, get my loved one out. So what do? Well, one common remedy is they go talk to a bail bonding company. And the bail bonding company essentially says, hey, pay us a percentage, typically 10%. So pay us 10% and we'll get the person out. And as long as that person shows up, then we've made that money. So if the bond is $1.5 million, the bonding company says, give us $150,000. We'll get him out. As long as he shows up, we've made $150,000. So of course you need to bear in mind that if you're paying the bonding company, whatever it is, that 10%, they keep that. That's their fee. You're never going to see that money again. Now, if you can afford to pay the total amount of the bail, $1.5 million or whatever it is, yeah, as long as the person accused shows up, you'll get that back at the end of the case. But again, that's not often practical. So what else can you do? Well, the other thing is you can have the lawyer ask the judge to reduce the amount of bail. And the lawyer, if I'm the lawyer, I'm going to call up the DA and say, hey, can we reduce this? What's the arguments, or present my arguments to do so, to see if they agree, just because I think that the judge is more likely to reduce it if the state is agreeing. Sometimes they do, sometimes they don't. But whether or not the state agrees or doesn't agree, your lawyer is going to be required to present some argument to the judge to convince the judge, because the judge can disagree with your lawyer and the state. Say, I don't care what the state says, I'm not letting them out. So your lawyer has to try to persuade the judge to reduce the amount so that your loved one can get out. Now, what happens if that fails? Well, the only real option after that is to try to get the case to move along, and that's sometimes very tough to do. In other words, if I have a client who's in jail and they're not going to get out until we resolve the case, well, yeah, if I can resolve the case quickly, that's in my client's interest, I'm going to try to do it. But you have to understand, a lot of times, although a person who's accused of a crime is presumed innocent, that doesn't mean that the state presumes that the person is innocent. So a lot of times the prosecution thinks, hey, he's where we want him to be, we're going to let him sit there, and they're not going to be very helpful. In addition, the court systems across the country, and particularly in Alabama, are very clogged up, so it can take 3-4 years for a case to get to court. And if you have somebody who's wrongly accused, they're sitting in the jail for 3 or 4 years waiting for their day in court, and they don't get that time back. So it's not great, but that's the current state of affairs with that. Now, what happens after the issue of the bail issue? Well, the next big thing that comes up is what's called a felony exam or an initial appearance. It's really the same thing. And that's where a person appears in front of the judge. Hopefully the judge will explain to the person, hey, here's the basics of what you're charged with. Do you understand that? But the main focus is, are you going to ask for a court-appointed lawyer, or are you going to hire a lawyer on your own? So if a person says, I can't afford a lawyer, then the judge will have them fill out a form. And if they qualify, which most people who are in jail lose their jobs anyway, so a lot of people would qualify, they would get a court-appointed lawyer. A lot of people don't want a court-appointed lawyer. Hiring a lawyer on a drug trafficking case is expensive. And the reason it's expensive is that drug trafficking cases are very serious felonies. It's a Class A felony with very serious consequences, and they involve a lot of work, and lawyers charge more money for a case of that magnitude than for a simple little case. So that's the basics on that. Once the person has a lawyer, the next issue is, once a person has a lawyer, that lawyer will typically request something called a preliminary hearing. And that's a hearing before the judge where the judge determines whether or not there is probable cause for the case to go to the grand jury. And I'll explain that in a second. But a probable cause hearing means the judge is deciding, is there enough evidence to believe that this person may have committed the crime? He is not determining whether or not somebody is actually guilty of the crime. It's not a trial. He's just determining, is there reasonable grounds to believe that this person committed the crime that they're accused of? And as is usually the case, if the judge says, yeah, I'm convinced that there's enough evidence to believe that he may have committed the crime, it will go to the grand jury, which is another procedural safeguard for people. And the grand jury will once again look and say, oh, are we reasonably convinced that the person committed the crime? And if they say yes, then they will formalize the charges through something called an indictment. But going back to the preliminary hearing, if the judge says, hey, I'm not convinced, I'm not convinced that there's enough evidence to believe that he committed the crime, the judge can throw out the case. That's not as great as you would think it would be. The reason it's not as great is it's one of the few areas where the state of Alabama doesn't have to agree with the judge and they can still proceed. So the judge says, I'm throwing it out. State of Alabama says, fine, judge. They still present the case to the grand jury. If the grand jury is convinced that there is a sufficient evidence to believe that the person committed the crime, then they're going to issue that indictment. And guess what? The person gets arrested again and has to make bond again. So it's not a great thing, but most people would like to have their cases thrown out. And sometimes when the case is thrown thrown out. The state says, yeah, this is a crappy case, just leave it be, and that's the end of it. But after the preliminary hearing, again, the case winds up at the grand jury if it's not been dismissed otherwise, and at the grand jury, they're going to make that decision as to whether or not there is sufficient evidence. If they decide that there is not sufficient evidence, then the case can be thrown out, or what's called legally a no bill, and usually that's the end of the matter, although the state of Alabama can come back at some point in the future and try again. But generally, if the case is tossed, the state's going to say, we're not going to bother. If the grand jury isn't convinced, we're not going to try to present it to a jury. But if the grand jury looks at it and says, yeah, we think there's sufficient evidence to believe that this person may have committed the crime, then they issue that indictment, also called a true bill. The case proceeds to the next level of court. The next level of court in Alabama is the circuit court, which is the trial level court. And this is where the case is going to be resolved either with a jury trial or by some sort of negotiated plea or perhaps a dismissal. And this is where your lawyer is going to do the majority of his heavy lifting on the case, because he's going to look at, are there legal grounds to have the case tossed or to have evidence excluded from the case? He's going to look at, can we win the case if there is a trial? He's also going to, if you want him to, try to negotiate and see if there's a better potential resolution, etc. So one of the things that the lawyer does, in addition to examining the facts and seeing, what do we think a jury's going to do, is he's going to look at the legal issues. And if he thinks that there are sufficient legal issues, he will raise an issue before the judge. Usually it's called a suppression motion, where we lawyers are saying, judge, keep out certain evidence for a variety of reasons, the most common of which is the cops screwed something up, they did something wrong. So, for example, I had a drug case that I believe was trafficking case, but my argument was the cops messed up, you shouldn't allow the drugs in because of their mess up, and the judge agreed. So the prosecutor is left with a drug case with no drugs that he's allowed to talk about. So of course the case was tossed, my client won. I just had a case last week, it was a drug trafficking case, and I had asked for some evidence because I wanted to file a motion again saying that the police had messed up in some way. I got to court, the prosecutor was mad, although not at me. The prosecutor was mad because the cops hadn't supplied that information that the prosecutor needed and I needed to evaluate their conduct. And the prosecutor said, I've been trying to get this to you for 6-7 months. I'm sorry. I'll tell you what, I'll give you a one-day special for your client. And if your client wants to plead to a lesser charge, I'll let him stay out of prison and he'll still have a conviction, but for a less serious charge, and he won't be going to prison. And my client said, oh, heck yeah, I'm doing that. And that's what happened. So, and that was, did the police mess up on that case? I don't know. We never got the evidence, but it worked in my client's favor. So your lawyer's going to do, or should at least do, everything that he possibly can to help you. Let's say you go to trial. Of course, if you win, everything's great, you're done. But let's say you don't win. Now comes sentencing, and sentencing on a trafficking case is pretty scary. And it's scary because the lowest sentence the judge can give you is 10 years in prison, of which you must, by law, serve at least 3 years of that sentence. That doesn't mean you serve 3 years and you're released somehow. It means you have to serve 3 years before you can even be considered for any kind of program, parole, or whatever. And given how stingy the state of Alabama is about parole and release, you're likely not to get out after 3 years. You're going to be serving a good length of time. And that's the minimum. What's the maximum? The maximum is life or 99 years. So a person convicted of trafficking could die in prison. You can go out with a pine box. So it's a very scary matter. Now, if you're charged with a drug trafficking case, certain things that I think that anybody should do who can. And the main thing is you need to talk to a lawyer as quickly as possible. Preferably, you'll talk to the best lawyer that you know or that you can find on this. If you find yourself in this situation, you're welcome to call me and talk to me. My phone number is below. Even if I can't help you directly, I may direct you to some other lawyer, depending on where you are in the state. But I would urge you to contact a lawyer right away if you're charged with trafficking. I hope you found this video to be helpful and informative. Thank you for watching.